Welcome to another episode of Titan PI TV. Here at Derby, looking at the inside workings of an operational investigation agency, that being Titan. So today we're going to look at GPS vehicle trackers and their legitimacy. So this is a question we get asked an awful lot by prospective clients. Are they legal to use? Simple answer, yes. However, there are criteria we need to stick to and laws and legislation we need to consider. Those laws and legislations, the first one is GDPR, the General Data Protection Regulation. The second one is the Data Protection Act, 2018. Protection from Harassment, 1997. The Human Rights Act, 2010. The Regulation of Investigatory Powers Act, which is RIPA, which is 2000. Vehicle Interference, which is the Theft Act, 1968, Section 12, and Civil Trespass. So we have a client that contacts us and their intention is to deploy a GPS vehicle tracking device on an individual's vehicle. So we need to first of all consider legitimate interest. Effectively, is it lawful? Is this client wanting to stalk or cause harassment, alarm or distress to the individual? Clearly, if that is the case, then we can't proceed. So we've been told it's for example, a matrimonial investigation. The subject, who is the husband of the client, believes that husband might be having an affair. They want to know where his vehicle goes during the day or who it meets, etc. So that is the objective. So we need to do our legitimate test. If we fail the legitimate test, which I'll come on to in a minute, then we are potentially going into the realms of committing an offence under the Protection from Harassment 1997, which clearly we don't want to do. So there are two mnemonics which we use here at Titan, or we use one of them. The first one's Japan, and the second one is plan. So when we have a client contact us, if we look at Japan first, is the objective and are the intentions justified? Are they accountable? Are they proportionate? Are they appropriate? And are they necessary? So that would be Japan. If we use the plan mnemonic, is the objective proportionate? Is the objective lawful? Is it accountable and is it necessary? So we need to answer yes to all of those. If the answer is no, then we need to go away and think of another method. But we need to have yes to all of those areas of either Japan or plan. Once we've answered yes to all of those, then we need to complete a legitimate interest assessment and also a data protection impact assessment. These forms are readily available on the ABI, which is the Association of British Investigators, and also the IPI, which is the Institute of Professional Investigators. They're available on their website, and I know that the IPI have recently done a data protection toolkit, which I think I'm right in saying you can only access if you're a member. So we've answered yes to the legitimate interest criteria. We now move on to the planning. So the first question we need to ask is, where will the vehicle be parked overnight when we approach it? Is it on public property or is it on private? If it's on private property, we need to have permission from the owner of the property. So in this scenario, the husband, who's the subject, and the wife, who's the client, they live together, so the client can quite clearly give us permission to be able to walk onto their land for the deployment. If we haven't got permission, then we are committing a civil trespass, which is by its very nature a civil offence, and we could be prosecuted for that civilly, not a criminal offence. So we've got permission. Next, we need to start thinking about the preparation and planning. So if there's poor preparation and planning, it could lead to a compromise where we are seen to be doing it, discovered doing it, maybe the police are called. Worst case scenario. So there is an element of luck despite preparation and planning. If the police are called, then potentially we are committing an offence under the Theft Act, which is Vehicle Interference, Section 12. Very unlikely that would happen. It would only be a holding offence because part of the points to prove for that offence are that you have to have the intention to take something from the vehicle or the trailer, so to commit a theft. So it would clearly be a holding offence because we obviously haven't got that intention. It's purely to fit a tracker. So that covers vehicle interference. Once the tracker is deployed safely, there's no compromise, we then need to think about what we're going to do with that data. So this is in my opinion. In my opinion, if we're using a tracking device as a surveillance tool, so we don't know anything about this person, so we need to get some pattern of life, some routine, so that we know when to deploy the surveillance intelligently. In my opinion, we are gathering no personal information simply because a tracking device only records location data. If we don't know who's driving that vehicle or who is a passenger in that vehicle, we are not getting any personal information. So it doesn't fall under the Data Protection Act, and we don't have to deal with it in accordance with GDPR. In another example where we are using the tracker as a surveillance tool, so we have a surveillance team on the ground, we are evidencing and gathering imagery of the driver, where it goes, who the passengers are. In that scenario, we are gathering personal data, and the data from the tracker will be classed as such. In that case, we would have to be in line with GDPR and the Data Protection Act. And we would have to retain, destroy, and gather that in a line with that. Another area we need to look at is RIPA. So this can be quite confusing, but for me it's straight up and down. So RIPA is the Regulation of Investigatory Powers Act 2000. This only applies to public bodies. It doesn't apply to us. The only time it would apply to us would be if our client is a public body, such as the council, wanting to investigate fly tipping. In that scenario, they would have to go through RIPA and get a directed surveillance. So it can apply to us, and we need to really take it in the spirit it's intended. And we've clearly done that with the two mnemonics I mentioned earlier, Japan and Plan. We also need to consider Human Rights Act. Once again, this only applies to public bodies, but if we're instructed by a public body, then it quite clearly applies. But once again, like RIPA, we take it in the spirit that it is intended. So we need to consider, not lawfully, but ethically, we need to consider two articles. The first one is Article 6, which is the right to a fair trial. And the second one is Article 8, which is the right to respect private and family life. If you stick to what I've just said and what Titan does, I believe that there are no grey areas. It's either it's lawful or it's not. And as long as you stick to the data protection impact assessment and the legitimate interest assessment, then you won't go wrong. That is trackers in a nutshell, and it is in a nutshell. There's more to it, but these are the basic things that need to be considered from a client's point of view, but more importantly, the investigation agency, which is actually deploying it. Thank you for listening. Another episode of Titan PI TV done. Please subscribe, give us a thumbs up, and we look forward to seeing you again. Have a good day.